Swayam Prabha. Digital India. Educated India.
Welcome viewers, this is Dr. Ashwini Sival from Faculty of Law, University of Delhi. I am here to bring very interesting, I am here and I have brought a new interesting lecture on intermediary liability and IP interface. Viewers, this lecture is lecture number 15 of the series called Law, Science and Technology. In this series, viewers, we have been talking about very interesting issues, and we have been covering very interesting issues pertaining to information technology, as well as augmented reality, virtual reality, AI, and legal a framework relating to AI, and so on and so forth. Today's lecture, my dear viewers, is quite specific to a particular subject, that is intermediaries liability. And intermediaries basically are the conduits in the virtual space who facilitate the third party content, or who facilitate the transmission or communication, or who host the information, etc., of the third party. So intermediaries have lot of privileges as far as the law, present law is concerned on intermediaries, but they have some liabilities as well. And in today's lecture we will understand why they have so much of freedom, and why there is a need of bringing some check, or curtailing their unfettered freedom in the internet space. So specifically, we will see it in the context of intellectual property, or matters pertaining to intellectual property, because it has been observed, or it is observed that lot of intellectual property protected matters are disseminated or communicated, or hosted of intellectual property owners by the intermediaries, and the intermediaries go scot free, they are not made liable. So let us begin this lecture with this backdrop. Let me give you the brief background about the issue. The internet has grown phenomenally, and the problem of online infringement has, as a corollary, has also resulted, or has also proliferated meteorically. So when it comes to infringement of intellectual property rights on the internet, or in the virtual space, it has assumed gigantic proportions, and it has developed into an economically significant issue, because intellectual property protected subject matters are usually very lucrative. So we will see how many kinds of intellectual properties are there which are vulnerable to be infringed by the intermediaries, or through intermediaries in the cyberspace. The commercialization and exponential growth of the internet has created an entirely new set of problems for intellectual property holders. Well, we all know that these days internet has assumed a great magnanimity, and with the growth of the internet, and especially the exponential growth of the internet, we see that a new set of problems for intellectual property holders have arisen, or are arising day by day. While the internet allows the content community comprising of researchers, educators, artists, publishers, and music and entertainment industry to expand their markets at an unprecedented rate, the same technology allows any anonymous and invisible pirate to copy and disseminate instantaneously anything that is available on the internet. So you see that internet has some advantages, it has some disadvantages too. When it allows the educators, content creators, or artist publishers, and music composers, or music creators, or entertainment industry to publish, to express, or to have the commercialization of their works. At the same time, it gives a lot of space or scope to the anonymous unscrupulous entities to pirate or to copy anything or to disseminate it electronically, which is a violation of intellectual property holders' right. So, when we see intermediaries liability in the context of intellectual property, we find that intermediaries role is very crucial to uphold the intellectual property rights of the intellectual property holders, but it rarely happens, or if it at all happens, then some kinds of immunities are always pleaded by the intermediaries to defend themselves, especially the exemptions which they have under the international regime, as well as at the domestic level. They have lot of exemptions, like they can always apply for some safe harbor. They can always assert that they are not at all liable because they are just hosting the third party content. They are not themselves modifying or disseminating, they are just hosting and they are just facilitating the communication or correspondence. So, under the guise of this kind of a safe harbor, or the immunity from the liability, they do keep on doing the contributory infringement, you may say, or they may keep on doing the infringement through their contribution to the real perpetrators or the primary infringers, right. Now, online intermediaries basically, if we will wish to define them, they are unconscious actors in the internet transaction, and they have no pre-existing legal relationship with other actors, because their role is of facilitating correspondence, communication, or transmission of the content, right, or hosting any third party content or link, but they do not have any pre-existing legal relationship with the party whose content they are hosting, or they do not have any pre-relationship with the party whose intellectual property they might infringe while hosting third party intellectual property. So, the virtual world of cyberspace is abounded with all the echelons of human society, be it artists, statesmen, organizations, businessmen, individuals, or so to say criminals. Without the agency of human hand, the virtual world will not exist. Thus, though the criminal act may be committed in an utmost intangible environment, its perpetrators are but the real world. So, we see that the virtual world has the presence of all the echelons of the society, the musicians, the composers, artists, publishers, etc. Even the criminals are also equally present and omnipresent in the virtual space. Without the agency of human hand, the intellect, this virtual space will succumb or will not exist. So, we need intermediaries, we need all the echelons like artists or content creators or publishers, etc., for it to thrive and strive. But what kind of a balance is to be made in order to have that harmony or prosperity of both the parties? That is something which is a matter of debate, or which is a matter to be brainstormed. So, the liability factor in the internet arena is exacerbated by the anonymity and intangibility. In the case of intellectual property especially, the properties are intangible in nature, and their dissemination, their infringement or violation in the form of communication by a non-right holder, in the form of reproduction in the electronic form, in the form of issuance by a non-right holder, is very easy because of intangibility and because of anonymity. So, it has become hallmark of crime being committed in the internet age. It is seen that ISPs have taken multifold roles, like that of access providers, network providers, and as of hosts, and with it the liability falls into different components depending on the particular role of the internet service provider involved in the respect of a disputed act. Well, the internet service providers or intermediaries, they are not interchangeable terms, because in the case of internet service providers we refer to only those entities which provide the internet services. But when it comes to intermediaries, they may be any entity whose whose role is to host your content, whose role is to transmit or transact, or whose role is to communicate or host or facilitate the communication, etc. So, they are not necessarily the internet service providers, but they are intermediaries. ISPs are also intermediaries. Even the web cafe service providers in India, according to the definition of intermediaries, are intermediaries, including the internet service providers, right. So, effect of uncensored online content is very intense, so much so that it can incite someone to commit an offence. It is very serious issue that the criminals these days may commit criminal acts because the online content which is uncensored, mostly in the nature, is being hosted by the third parties, and they do not apply their due diligence, or you may say they do not apply reasonable practices, standard practices, in order to thwart such content to be communicated. And online content being uncensored, leads to what? Leads to incitement of the crime, incitement of the violence, or incitement of communal tensions at times. So, the role of intermediary or their relevance, including their obligation or their duties, are of utmost importance, or are very, very significant for the law students and for students who are interested in discipline to understand. Now, coming to the intermediaries, who are they and what do they do and where are they defined? Let me tell you, intermediaries in the internet context are organizations whose services are used to facilitate a transaction between communicating parties. They are basically organizations, they are not necessarily the internet service providers, they are rather organizations whose services are used to facilitate a transaction between communicating parties. The originator and the addressee, if they want to communicate, it is the intermediary who will facilitate their communication. It is the intermediary who will host their communication. Intermediaries are several in number and consist of transmission hosts, resource hosts, including website host, newsgroup host, FTP site host, DNS host, communication services including internet service providers, directory service and transaction facilitation services including domain name allocation, identity services and payment services. So, intermediaries are as I told you earlier, they are several in number, and they cater to the internet in various and multifarious ways. Some are hosting communication, some are facilitating payment, some are facilitating social media, some are facilitating DNS hosts, some are newsgroup hosts, etc., including the internet service providers. So, when it comes to their legislative definition, we have the legislative definition provided under the IT Act of year 2000, where under section 21W intermediary is defined, and intermediary under this definition or under this section means or reads that with respect to any particular electronic records, it means any person who on behalf of another person receives, stores, transmits that record or provides any service with respect to that record, and includes telecom service providers, network service providers, internet service providers, web hosting service providers, search engines, online payment sites, online auction sites, online marketplaces and cyber cafes. So, this 21W of the IT Act gives a very wide definition of intermediaries, and this definition is exhaustive so far as the rules of interpretation in the legislation, in the legal education or in the legal field are concerned, because here they uses the word means. So, all these categories are the final categories to be called the intermediaries. According to the legal definition under 21W, no one else can be called technically the legal intermediaries except these as mentioned here. So, to quickly give you the recapitulation, to quickly recapitulate who all are intermediaries for any particular electronic record. Under this definition, any person or who on behalf of another person receives, stores or transmits that record can be the intermediary or can be called the intermediary, or any person who provides any service with respect to that record can be called the intermediary. Then telecom service providers, it is the second category which may be called the intermediary here. Then network service providers is the third category who may be called the intermediaries here. Then service internet service providers is the fourth category who may be called the intermediaries as per this definition. Web hosting service is the fifth. Then search engines, even search engines, sixth. Online payment sites, seventh. Online auction sites, eighth. Online marketplaces, ninth, and cyber cafes, 10th. So, there are overall 10 different intermediaries which has been listed under the definition provided under the IT Act of year 2000, under 21W of IT Act. And basically section 2 of any act for that matter in the India, mostly legislative drafting is such where section 2 is the interpretational or definitional clause. So, they have defined intermediary under section 2, which means person, which means telecom service provider, which means network service provider, internet service provider, web hosting service provider, search engine, online auction sites, online payment sites, online marketplaces, and cyber cafes. So, according to this, even e-commerce sites are what? They are intermediaries. According to this, online auction sites for bidding etc. are intermediaries. According to this, online all search engines like Google or Yahoo or Safari, they are all basically intermediaries. Even web hosting service providers are intermediaries according to this definition. So, I believe that by this brief introduction to the definition of the word intermediary, the viewers are in a position to understand what does intermediary mean and what do basically they do. Moving ahead to the levels of liability of the intermediaries. So, let me tell you viewers that the intermediaries have the immunity, or they enjoy the immunity under the legislative framework in India and abroad, or almost in all the jurisdictions, because it is exigent to provide them some free hand, otherwise they may not be able to efficaciously operate, and this this may lead to non-functioning or inefficacious functioning of the search engines or web hosting services or internet etc. So, when it comes to knowledge level of liability, the knowledge or control over the information distributed by the ISP is the key factor in determining the liability of ISP and computer system operators. So, what kind of information is being shared, that basically determines their liability. What kind of information is being shared. So, knowledge and control over that information being distributed is the key factor in determining the liability. Even in the pre-internet age, levels of liability were different in case of publishers, distributors, common carriers, right, and even now it is different in the case of publishers, distributors and common carriers. Thus, an ISP may perform the functions of an access provider, software distributor, host, cache or content provider. As content is disseminated in a borderless world. Basically, the contours of liability of these online intermediaries, including the ISPs, are in connection with the content which is transmitted, copied or possessed by them, and which often offend the rights of individuals, which either arise of a contractual bond or are simply some sort of a tort or criminal offence like defamation, copyright infringement, child pornography, false advertisement, fraudulent misrepresentation, breach of confidentiality and privacy, and so on. So, you see that ISPs perform different functions, and with respect to their different functions, they may be made liable, and contours of liability may vary, right. If it is a search engine providing a false advertisement, their liabilities may be determined in the context of they being providing misleading advertisements. If it is some platform which is promoting child pornography or hosting child pornography, so their liability will vary according to the legislative framework pertaining to child pornography. If it is a defamatory content which is being hosted or which is being transmitted, then it is the different liability which is to be imposed, or which they will incur, or which will accrue. So, it varies. So, let us have a look at couple of legal frameworks which basically are handy, or which are decisive in order to understand the concept of intermediaries and their liability. Well, legal frameworks dealing with intermediary liability usually use two kinds of regulatory structures. One is horizontal. This approach is singular, where a single liability regime applies to any infringement irrespective of the area of law, right. And there is another approach that is called vertical approach, where different liability regimes will be applicable according to the specific domains like copyright, defamation or child pornography. In India, we follow the vertical approach, where different liability or levels of liabilities are different with respect to the crime committed, or with respect to the infringement, or with respect to the defamation, with respect to the offence committed by the intermediary in the virtual space. So, the main statutes that create this vertical framework in India, they are as follows. We have first and foremost the Information Technology Act, that is the landmark, or that is the most important statute so far as intermediary liability is concerned. Then apart from the IT Act, we have some sections interspersed in other laws, other statutes, like under the Copyright Act we have section 63, 51A of the Copyright Act, and under section 104 of the Trademarks Act also the liability of intermediary may be fastened or fixed, and their sweep or scope applies to intermediaries, including the sweep of IT Act, which is, I said, is a benchmark law. Then if we go specifically or talk specifically about the IT Act, we have section 79 of the IT Act, which affords intermediaries immunity from liability, and it allows intermediaries to claim exemption from liability for offences under general laws such as the Indian Penal Code and the IT Act itself. This section has always been the matter of controversy when it comes to intermediaries or their liabilities, and it is in respect of or in the context of any subject matter, be it intellectual property or defamation or pornography or so on and so forth, but section 79 of the IT Act basically accords immunities from liability or immunity from liability to these intermediaries, and they claim their exemption from any offence under general laws, right, such as IPC and under the IT Act itself, because none of the provisions of the IT Act shall be applicable or none of the provisions of any other law shall be applicable predominantly if they satisfy the requirement of to fetch this liability from the offences under the Information Technology Act under section 79. So, let us have a look at section 79, which is more popularly known as a section providing a safe harbor to the intermediaries. It provides a safe harbor to the intermediaries, and this safe harbor to the intermediaries, as I said, has always been a matter of debate or brainstorming, and there are many case studies which attract or involve these sections to understand the role of intermediaries or their liability in certain cases. Well, coming to section 79 or its legislative reading or legislative definition, it is a non obstante clause because it starts with notwithstanding. It is a non obstante clause. Non obstante clauses are those clauses which are having the overriding effect over the other laws or the laws mentioned therein. So, it reads that notwithstanding anything contained in any other law for the time being in force, but subject to the provisions of subsection 2 and 3 of this section, an intermediary shall not be liable for any third party information, data or communication link made available or hosted by him, right. So, it reads that notwithstanding anything contained in any other law for the time being in force, but subject to the provisions of subsection 2 and 3 of the section 79, the intermediary shall not be liable for any kind of a liability for hosting third party link, for communicating, for information sharing, for data, etc. And the reason of the same is that we are bound or any other country for that matter who is a signatory of the international norms in this regard are bound to abide or comply with the international norms, where safe harbor is something that has to be necessarily accorded to the intermediaries by the domestic legislations catering to the information systems or catering to the computer networks or catering to the computer systems into their respective nation states. But the safe harbor or this immunity, so basically under 79(1) the intermediary has got what? Under 79(1) the intermediary has got a immunity from any kind of a liability. But this section 79(1) is subject to 79(2) and 79(3), wherein it is written that this immunity shall remain or will apply to the intermediary if the function of the intermediary is limited to providing access to a communication system over which information made available by third parties transmitted or temporarily stored or hosted. It is hosted, or intermediary does not initiate the transmission, does not select the receiver of transmission, does not select or modify the information contained in the transmission. So, there are some conditions or you may say preconditions for availing this exemption or immunity from liability for a service provider or for a intermediary under section 79. It reads that the immunity, the liability shall not be fastened or immunity can be accorded only if they satisfy the requirement of subsection 2 and subsection 3. And under subsection 2 it reads that the function of the intermediary, if limited to providing access to a communication system, or if intermediary does not initiate the transmission, does not select the receiver of the transmission, does not select or modify the information contained in the transmission, only then he or she shall the benefit of the immunity provided under 79(1), otherwise he shall be made liable. It further reads that the intermediary has to also follow the due diligence or observe the due diligence while discharging his duties under this act, and also observe such other guidelines as the central government may prescribe. So, if the intermediary is such who is not following the due diligence or observing the due diligence, or not following the guidelines prescribed by the central government in this behalf, or selecting the receiver of the transmission, selecting and modifying the content of the transmission, or is not acting just as a host or as a communication system for the information, then he shall be made liable under 79 of the IT Act, or you may say he shall be made liable under that vertical approach in any of the laws which makes that particular intermediary liable for pornographic content, for defamatory content, for a trademark violation, for a copyright violation, for a patent violation, etc. And further under subsection 3 of the section 79, it further reads that the provisions of subsection 1 shall not apply, or you may say that the exemption under 79(1) shall not apply if the intermediary has conspired or abetted or aided or induced, whether by threat or promise or otherwise, in the commission of the unlawful act, or upon receiving actual knowledge or on being notified by the appropriate government or its agency that any data, information, communication residing or connected to a computer resource controlled by intermediary is being used to commit the unlawful act, the intermediary fails to expeditiously remove or disable access to that material on that resource without vitiating the evidence in any manner. So, in that sense, it can be said, or by having read these two limitations on the immunity or on the safe harbor provided under 79(1), it can be said that the intermediaries does not enjoy any absolute freedom. Their freedom is there to enjoy by them or to exploit by them if they abide by the precondition illustrated, or you may say delineated, under subsection 2 and subsection 3 of 79. If they violate those preconditions, or if they happen to violate those preconditions, then 79(1) or its immunity shall not be accorded or shall not be available to be used by the intermediaries or to be availed by the intermediaries. But here the problem is that at times intermediaries pretend that they have been diligent, they have been careful, they pretend they have been wrongly notified, or they have been broadly notified or over notified, right, and so on and so forth, and they escape their liability even when they can be technically held responsible, because there lies their role in dissemination of a content, in selection of a content, in selection of a receiver of a content or its modification, etc., for their commercial gain. If you look at the search engines, or if you look at the modern day platforms like social media, etc., you find that there come lot of advertisements, unwanted advertisements, etc., all the time. They pop up, or they keep on popping up on your screen. So, that you have not signed up for looking at the advertisements there, but yet those advertisements are coming and appearing. So, in that sense there is something which you may say that some sort of a maneuvering is done by the intermediaries, because they are here ultimately to make some profit as well. And it is a well known adage that if something is free, then you are the subject who is being sold there, or when something is free, then your data is the oil for the intermediaries, etc. So, for the purpose of this section, the third party information may mean anything, it may mean any information dealt with by an intermediary in his capacity as an intermediary. Now, coming to one section which brings us to this title of this lecture, that is intermediary and IP interface. Here the proviso of 81 basically poses a IP interface. It poses a IP interface if you look at section 81 of the IT Act, you know 81 of the IT Act, then you find that this proviso says that nothing contained in this act shall restrict any person from exercising any right conferred under the Copyright or the Patents Act. And section 81 also in the main language reads that provisions of this act shall have effect notwithstanding anything inconsistent therewith contained in any other law for the time being in force. So, on the one hand the main language of section 81 empowers 79 by saying that the provisions of this act, provisions of this act means even section 79 will have a overriding effect, right, on the other laws which are prevalent or which are inconsistent therewith with this law. But at the same time the proviso takes away this the safe harbor of 79 by saying that nothing in this act shall restrict from exercising any right conferred under the Copyright Act and the Patent Act. So, is it the right interpretation, or is it interpretation which is not legislatively intended by the legislature, or which is not basically intended by the legislature? On the face of it, or apparently it seems as if 81 proviso nullifies or makes 79 or the exemption under 79 redundant. But is it true or not, it is a matter of inquiry for us to understand. But on the face of it, or apparently it seems as if 81 by its proviso takes away the exemption provided under 79 in the cases of intellectual property matters, because here copyright and patent is mentioned, which are intellectual properties. So, we will understand it with the help of some case laws, but before we understand it, I really want to make you understand what is this realm of copyright and internet, and then what kinds of intellectual properties may be infringed or may get infringed in the virtual space because of the intermediaries or because of the wrong deeds of the intermediaries. But to understand it, you need to understand a bit of the copyright law, or a bit of the contours of the copyright law. Well, copyright infringement in the virtual space has gained great significance or attention most recently due to the piracy of the movies and because of the unauthorized distribution of the movies. With the advent of these MPEG-5 technology, online movie piracy has become more and more common. Assuming that subject matter is eligible for a copyright protection, like a movie or any content created by a person, the two requirements are to be fulfilled for any content to be eligible to be accorded a copyright protection. One is the concept of requirement of originality, another is the requirement of fixation. When it comes to originality, any content created by any person, be it possessing only minimal amount of creativity, is protected under the copyright law, or is very valid subject matter to get a copyright protection. And simultaneously it has to be fixed, or some form or expression has to be given to it by the author of particular expression or by the author of a particular work. So, if these two things are existing or available, then copyright may be conferred on any creation like on a literary, artistic, or on a dramatic, or a musical, or a sound recording work, or even on a cinematograph work, which are popularly known as cinefilms, or which are popularly the subject matters of piracy. So, the requirement of originality is basically very minimal, or very you may say the threshold of the requirement of originality is low in the case of copyright, vis-a-vis to the threshold of novelty in the case of patent protection. This is not not even near to the requirement of novelty of a patent protection. Originality is modicum of creativity or minimal amount of creativity, which means, according to the judicial dicta, which means that the work must originate from you and it must not have been copied, right. That work shall enjoy the minimal amount of creativity, and subsequently that shall enjoy the copyright protection. And moreover, under the copyright law, the protection is automatic, it is an automatic protection regime, where your work created by you immediately fetches the copyright protection, irrespective of following a formal procedure or a process to attain the copyright protection formally. So, no requirement, it is purely optional. You may have a copyright protection just by creating a particular work, and which makes it all the more complicated. You have created a work which has a minimal amount of a creativity, which is fixed by you, or which has satisfied the condition of fixation. So, in that case, your work may be exploited by somebody on an internet, or through some intermediary. So, who shall take care of it, whether it is a copyrighted work or not, and who knows whether it is a copyrighted work or not? The intermediaries are duty bound to apply their due diligence, and when it comes to due diligence, it is imperative on them to use some filters, or some mechanism, right, some right management mechanism, so that the rights of the right holders will not get thwarted or infringed or violated in a cakewalk manner by the unscrupulous entities. For establishing a prima facie case under the copyright suit, or in the case of a copyright infringement, it only requires that the plaintiff prove ownership of a valid copyright and copying by the defendant. And copying is shorthand of what? Infringement of the owner's exclusive right, or owner of a copyright owner basically owns an exclusive right which gets infringed, and his exclusive right is basically are too many. He has many rights under the copyright, like right to communicate, right to disseminate, right to issue copies to the public not already in circulation, right to broadcast, right to reproduce, right to translate, right to adapt, etc. So, proving copying of a work through the use of a computer on the internet is not a difficult task. Courts have held that copying of a work occurs when information is transferred from a permanent storage device to a computer's random access memory. The simplest example of this is when a work, an image, a written document, or other work is transferred from a floppy disk or any medium from which a work can be viewed to a computer's central processing unit. A very similar process occurs when a web page is created. A web page designer creates the pages viewed through a web browser such as Netscape, Navigator, or Microsoft's Internet Explorer using hypertext markup language. Is a computer code that enables designs and layouts to be viewed with consistency by web browsers worldwide. So, once a page is created and coded, the document is copied and placed on what is known as a server. So, the copyrighted works or copyright protected works may so very easily be infringed on the internet space, or in the computer systems, or through the computer systems. It is not a difficult task, and to assert that they have a copyright on a particular thing is also very easy in this case, because copyright requires only minimal originality and fixation, that is it. So, this makes it very complicated. The infringement is easier, so is the creation of a copyrighted content, and both together makes it very challenging for the intermediaries on the one hand, as well as the right holders of a copyright on the other hand, to assert their rights and to carry on their respective domains or into their respective domains. So, this takes me to some case studies. We have excellent case studies. One of the case studies which I am going to discuss with you is MySpace versus Super Cassettes Industries Limited. of the year 2016 decided by the Delhi High Court, and this case is very interesting. It is a case study which has factual metrics on your screen. MySpace is basically an internet service provider. This MySpace is an ISP, and it claims to be an internet intermediary, and it operates the social networking and entertainment website called www.myspace.com. Its website was first launched in the US, but it now has global outreach. Here users can access music works, entertainment videos, images, cinematograph works without paying any fee. So, it is a free platform called MySpace, where musical works, where entertainment videos, images, cine works, etc. can be accessed by the subscribers without paying any fee. Essentially, MySpace provides a free of cost platform to its users and offers an interactive user submitted network of friends, personal profiles, blogs, groups, and photos, music, video, instant messaging services, etc. So, it is a platform which even provides the option for the subscribers to interact with the friends, or instant messaging services, or the feature of sharing music, videos, etc. with the friends or social circle through this platform. And the question that arises here is whether MySpace has taken the rights, or more specifically the intellectual property rights from the respective copyright holders of the respective works like images, musical videos, entertainment videos, or cine works, etc., which are being hosted, or which are being transmitted, downloaded, or uploaded through MySpace or on MySpace. This is the key concern and the question. The MySpace's business model, in addition to acting as a conduit for information as an ISP, is also to provide automated ancillary services, whereby the limited license is sought from the user to use, modify, delete from, add to, publicly perform, publicly display, reproduce and display the user generated content, so as to facilitate access to user stored material, so that it can be converted into a format which is compatible with the website. It in addition to acting as a conduit or as an ISP for musical work, cine work, images, etc. to its subscribers, it also provides automated ancillary services, whereby a license is sought from the content providers, so that the intermediary MySpace can modify their content and delete, etc., or may publicly transmit that content. This license is sought by them from the subscribers only in respect of their automated ancillary services. They claim not to derive any monetary gains from its user generated content. While advertisement is its chief source of revenue, the advertisements are not marked directly against the UGCs, but are against the licensed content through a service known as AdWords. Now, it has become very interesting case study that they say that they do not derive any monetary gain from the user generated content. Their main source of revenue is the advertisements, and in the advertisements they do not directly mark these advertisements to the user generated content, but they mark the advertisements against licensed content which they are lawfully allowed to modify, delete, or make any changes into that content, because they have taken a license from the respective owners of that content. But what about those content or that content for which they have not taken a permission from the right holder? Can they also attach these advertisements against that content? And even if they do not attach any advertisement to that content, can they still use that content and disseminate that content, because one of the rights under the copyright law given to the copyright holder is the right to communicate the work to the public. Reproduction alone is not the copyright infringement. Even unlawfully, unauthorizedly communicating someone else's work is infringement in the eyes of the copyright law. Issuing that work to the public is infringement in the eyes of the copyright law. So, they are technically contravening many things. They are contravening the reproduction right, because they haven't taken the copyright license from the owners of the copyright in this case. Secondly, they are contravening the right to communicate that work to the public of a copyright owner, which is also a equally important right of a copyright owner. And by claiming that they are not deriving any monetary gain, they can't escape the liability, because they are presupposed to apply due diligence or exercise due diligence, and that due diligence of section 79(2) requires them, mandates them, obligates them to apply reasonable diligence while using someone's work before uploading it or getting uploaded it on the platform, and then letting other users to download that. In this case, the affected party, that is SCIL, known as T Series, it pleads that it started its business in recorded audio and video cassettes production, and their business flourished to become one of the India's largest music companies. It now owns and controls copyright in more than 1 lakh songs in various languages. So, they say that they own copyright on 1 lakh songs. As I said, that getting a copyright is very easier. It requires minimal creativity or originality and fixation. So, the SCIL here asserts copyright on 1 lakh songs, and it seeks permanent injunction restraining MySpace from reproducing, adapting, distributing, communicating, transmitting, disseminating or displaying on their website any content the copyright of which exists with it, and also sought damages. So, these are some of the rights which a copyright owner enjoys, like adaptation, distribution, communication, reproduction, and all has been violated or has been alleged to have been violated by MySpace here, by the SCIL. Now, which are the prominent sections going to be attracted here? As we discussed 2 sections of the IT Act which are going to be attracted here, apart from the provisions of Copyright Act, right. We all know that Copyright Act under section 51 talks about infringement, and under 63 provides remedial measures for taking necessary action for the infringement of a particular intellectual property. So, or copyright infringement in this case. So, here MySpace asserts the exemption or a safe harbor of 79, and it says that they are not liable because 79 is providing them the immunity, and it is providing them the exemption from any liability when they are acting like a intermediary, right. But now the question comes whether they really acted like an intermediary, and it is a matter of fact, not of law, to determine it or to gauge specifically whether they acted like an intermediary or whether they acted beyond an intermediary. They may be called acting beyond an intermediary when they start tinkering, modifying, deleting, or changing or selecting the receivers, etc. of particular information. Section 81 also comes into the picture here, because section 81 says that notwithstanding anything contained in any other law, the law under the provisions of the IT Act will have an overriding effect, and 79 will have an overriding effect, which means that they are immune. But this interpretation makes this provision otiose. If they are immune, even if they are doing the infringement, then it means that this particular language is otiose. But proviso to section 81, comes to rescue, or here plays a very significant role, which says that irrespective of it, the owner of a copyright or a owner of a patent can exercise his or her right irrespective of the overriding effect of the IT Act. So, which means that this overriding effect under 81 of 79 has been diluted by the proviso, right. And if it has been diluted by the proviso, then here in this case the MySpace can be held accountable, right, because what they have done, they have infringed the copyright of these copyright holders or copyright owners, and the division bench of the High Court of Delhi interpreted these provisos harmoniously by saying that the proviso neither dilutes nor takes away the spirit of 79. It rather provides the opportunity to the victim or to the infringed party to explore the remedy of both the provisions. Like copyright, trademark, patent, they are special statutes, and special statutes can be invoked for remedial measures pertaining to special subject matters. Simultaneously, the safe harbor shall or should also be provided to the intermediaries, because it is not an absolute safe harbor. Within the specified subjection of 79 2 and 3, the safe harbor shall still remain available to the intermediaries. So, it is a matter of inquiry into a particular case whether the safe harbor should be provided to the intermediary or not. If he has not acted beyond intermediary, or if he has acted just like an intermediary, then he shall have a safe harbor and he will enjoy the immunity irrespective of any provision for that matter which takes away that immunity, or any proviso which basically curtails that immunity or dilutes. So, the law was interpreted harmoniously, and in this case it was held that MySpace, by the division bench, it was held that MySpace has infringed. But on the contrary, it was also observed by the court that the SCIL has to specifically inform the MySpace as to which of his works are being violated on MySpace. They can't just generally inform MySpace that their 1 lakh songs are copyrighted and they are being violated. Rather, it is categorically required on the part of the copyright holder to provide the links or URLs of the infringement, as well as to specifically show that this particular copyright is being, or copyrighted subject matter is being infringed. Only then they can assert their remedial measures, or they can seek injunctions, etc., and can stop the intermediary from causing the further infringement of the intellectual property. So, this is what happened. To summarize, I will say that 79 and 81 and 51 of the Copyright Act have to be read harmoniously. Accordingly, it is held that proviso to 81 does not preclude the affirmative defense of safe harbor for an intermediary in case of copyright actions, and this 51 in the case of internet intermediaries contemplates actual knowledge and not general awareness. So, the onerous duty of the SIL is to tell specifically which of his works have been infringed. Additionally, to impose liability on intermediary, conditions under 79 of the Act have to be fulfilled. In case of internet intermediaries, interim relief has to be specific and must point to the actual content which is being infringed. They can't generally assert that their work is being infringed, they have to point out specifically which content is being infringed. So, this is all my dear viewers, but I would lastly say that when it comes to intermediaries and their liabilities specifically in relation to IP or intellectual property subject matters, we have adequate provisions or adequate laws in place in the vertical approach, and our new intermediary rules of year 2021 are also specifically highlighting the intermediaries and their liabilities and their duties, and they are casting stringent duties on the intermediaries now. So, with this note I will take your leave, and I am looking forward to meeting you again with some more interesting and informative lectures in this series called Law, Science and Technology. Thank you very much, viewers. Have a lovely evening.